Your divorced spouse might qualify to receive Social Security benefits based upon your work record if she meets specific criteria. And she can do so even if she is eligible to receive benefits based on her own record. How exactly does that work? Live at 5's family attorney Sonia Kaufman joins us now with answers. So how does that work? She gets your Social Security benefits?
She can draw on a husband's record, but it doesn't reduce what he receives. And he may not even be notified of that. She just has to make application if she was married at least 10 years and if she remains unmarried at age 60.
Okay, well, pretty easy. All she has to do is file the paperwork.
That's right. And she would make the election of which benefit would result in the greatest payment to her. She could either draw on her own record if she's eligible in her own right, or she could draw 50% of her spouse's record if she's been married at least 10 years.
So do you find many people are doing that these days?
Absolutely. What some people are doing, they are deferring drawing on their own Social Security because the longer you wait, the greater the benefit, the greater the payment, and drawing on the spouses in an interim period starting at an earlier time. But you can't draw both. At some point you have to make the election.
And the stipulation is you can't have married once you have divorced that person.
Right. And there are cases where people remarry before age 60 and then divorce prior to age 60 in order to draw a former spouse's benefit, and then you can remarry after age 60 without affecting it. So it really pays to know your options if you're thinking of that.
Just talk to a lawyer.
Yes,
that's the
absolutely.
best thing. Some more questions. If you have a child with an unknown parent, what is the process for a man to adopt this child?
The rights of the unknown father have to be terminated, and someone would need to check with the paternity registry in Austin to see if someone has registered regarding that child. And if not, then that would end the question of terminating that person's rights, and a step-parent could step in and adopt.
Okay. If a child is 9 years old, can he determine which parents he wants to live with now, or does he have to wait until he's 12? We get this question a lot.
We do, and you know, I've always sounded so confident that the child never gets to choose. The law says what's in the best interest of the child, but I have noticed more and more that judges are deferring to the wishes of children, even as young as 9 sometimes. I guess if it were an extreme situation, the court might say, no, you can't live at a particular parent's house, but more and more kids are having a greater voice in that. The law is, of course, that the judge is required to listen to the preference at age 12, but certainly can listen to the preference of younger children based on the court's discretion.
But you have to go back to court to get that changed.
You do. If you're going to get a legal order changing that possession or even custody, you need to go back for an order.
Okay. I'm supposed to have possession of my children this month, and I've bought tickets to Disney World. Their mother lives in Austin and did not put them on the flight. I have not been able to reach her by phone. What can I do?
Wow, that's so inconsiderate, isn't it? Oftentimes the order will have a provision that if a parent doesn't put the child on the proper flight, they're to put them on the next available flight and make the notification. So if they haven't done those things, they're in contempt of the order. And the legal remedy is to file an enforcement, and certainly would ask for reimbursement of out-of-pocket expenses that caused, ask for makeup time to be able to take that trip, and ask for attorney's fees for having to go to court to do that.
Oh, goodness, that sounds like a mess. My husband gambled away $40,000 in the past several months. Is there anything that the court can do in the divorce?
Yes, the court can consider wasting of community property, and gambling is a classic example of wasting. So I think on the inventory of the couple's assets, there would be a fictitious number of $40,000 that the court could potentially award to the husband, thereby giving the wife other property to make up for that.
Okay, I think we can squeeze in one more question. Is there a way to get divorced through mutual understanding? What about custody of the kids?
I guess they're asking about a divorce based on irreconcilable differences and uncontested
and then what do you
divorce.
do with the kids?
And if it's an uncontested divorce, they have to reach an agreement, and then the final decree would reflect that agreement, and it becomes an enforceable order once the court signs it.
All right, Sonia, as always, we appreciate you stopping by.
Thanks
and if you'd like to have Sonia answer one of your questions, all you can do is fax us 892-7305, email us at laf@kftm.com, or you can post those questions on our KFDM News Facebook page.